Inquiry Chairperson Raymond Zondo is in a statement today clarifying what the historical and family issues raised by former President Jacob Zuma really do mean. Now, the Deputy Chief Justice was asked to recuse himself because of these said issues. Zondo has since revealed that he fathered a child with the former president's sister-in-law. Joining us now to unpack these legal implications in practice is advocate and legal expert Mudidima Manya. Advocate, good evening and thank you for your time tonight.
Good evening, Thabo, and good evening to your listeners.
Now, give us a summary in terms of the legalities, right? In terms of law, when is the recusal of a presiding officer appropriate?
Well, firstly, let me indicate that the decision on a recusal is that of the presiding officer himself or herself. Of course, in law, there is a test of the type of circumstances where a person in the position of the Deputy Chief Justice will have to look into on whether he must recuse himself. The law does make provision for situations where there are proximities in relationships and, and depending on the degree of intimacy between the people involved. But we must be very cautious. In this particular instance, the mother of the child is not a participant in the Zondo Commission. She is neither a party, she is not a legal representative, she is not a witness in the proceedings. I guess that the impression which has been created is that because she is a sister to the wife of the former president, then the insinuation must be that a former deputy, the Deputy Chief Justice, has got some discussion on this matter. But we are talking about something that happened, from what I hear, over 30 years ago. The Deputy Chief Justice was hardly a judge at that stage. So I'm not sure what is the relevance of this relationship, because from what he says, there's no proximity or intimacy in any way. Yeah. So I'm not sure what is the relevance of the fact that he has got a child with the sister to the former president's wife.
Now, the legal team of the former president outlines in that letter, and by the way, we must be clear that there is no application that has been made to our courts as far as we know at this point, except for this letter that is out there that was sent to the Chief Justice, with the Deputy Chief Justice is now responding to. But in this letter, it says our client reasonably apprehends that you have already adopted a biased disposition towards him and cannot bring an impartial mind to this issue. Does the apprehension in itself automatically mean that the presiding officer will need to accede, or would that apprehension have to be assessed in terms of true facts?
Look, the law doesn't require that there be actual bias. It requires that there be at least a reasonable apprehension. So whatever apprehension must be of a reasonable nature. But let me point out a few facts that are concerning in this matter. Deputy Chief Justice Zondo became a Chief Justice in June 2017, and judges are appointed by the President of the Republic. The former president was, at the time, the head of state. I'm not sure whether this matter should have been raised at that stage, because this conflict of interest must have a meaning at some point. When Deputy Chief Justice Zondo was appointed to chair the commission, this information was known, and it doesn't seem to have been a factor at that stage. Deputy Chief Justice Zondo has presided in a number of cases which involved the former president, including in his capacity as head of state, and this matter of this historical family relationship doesn't appear to have arisen at any stage. So it is a bit of a challenge, I suppose, but the onus is on the former president to make a founded case of that reasonable apprehension of bias. And I think the challenge we are confronted with at this stage is that there is no substantive application for the recusal of the Deputy Chief Justice. So it's difficult to really say whether there are, reasonable grounds of success in that application. All what we have seen thus far is a threat to approach a court. But I think the Deputy Chief Justice himself has made it very clear that he will only make this clarification and he will not respond to the rest of the issues. He's awaiting an application for recusal if such an application is ever made.
Now, should the litigants' motive in raising this so-called conflict of interest be questioned? I'll tell you why. Because maybe not in this matter, but in any other matter where the accused has all sorts of other motives. Maybe they would want the matter to be presided upon by an officer who will rule in their favor, and they can raise this question or this apprehension of bias. So should the litigant's motive be questioned in the matter?
Well, yes and no. Look, Thabo, you will agree with me that if you find yourself in a difficult set of circumstances, you would obviously look at anything and everything to extricate yourself. And I don't think I can blame anybody for trying that. The question, though, remains whether you are going to be able to make out a case for a recusal at any stage. And there are cases, because that is why there's a body of case law which has now defined the circumstances under which this happens. For instance, there's a judgment involving a magistrate whose wife was a witness in the case, and the court said, but clearly we cannot have this. The current Chief Justice presided over a matter where his wife was the state advocate, and the court said, look, there's too much proximity and intimacy, an ill motive or an agenda. But I think in the context of the present case, of course, one can infer, probably, having regard to what I've said, that, this is a 30-year-old story, this has never been raised before, the former president has already appeared. But I ask the question, it is not the Chief Justice or the commission investigators who are making allegations. It's people who are making this allegation. What the commission is doing is to afford everyone who is implicated his or her procedural rights. And people can choose to go there and not say anything, or can choose to go there and respond and make a rebuttal of the allegations that are made, or admit those facts that they admit to be correct.
Yeah. Now, considering that, the commission is not a court of law, right? It's trying to fight. It's a fact-finding process in its particular nature. Do the same kind of rules of processes of recusal apply in the instance of a commission of inquiry?
Well, firstly, let me point out that the Deputy Chief Justice is a judge. So he is expected at all times to meet the highest threshold of what is expected of a judge in any event, regardless of the fact that he's chairing a commission of inquiry. But secondly, it is important to understand that at any given stage, anybody can come out and raise whatever he wants to raise. The Chief Justice, Deputy Chief Justice, has an obligation in law to act in a reasonable, fair, and procedurally correct manner. So it does not necessarily follow that because he is a gatherer of facts and not a trier of facts, that he can just do as he wishes. You would have seen the proceedings that he does contend with the various issues that judges sitting in the court do contest with. People come and ask for a postponement. People come and say, well, you must recuse yourself. I want a document. That is the normal trouble that judges go through every day in the courts.
Now, of course, you mentioned this, that the presumption is that a judge will carry out his duties as per the oath of office, and that they take that seriously, and everything that they will conduct will be fair, will be without a bias, and so on and so forth. Was it necessary for the Deputy Chief Justice to clarify in that note today the relations between himself and the former president?
I think it was necessary, and I think I commend the Deputy Chief Justice for clarifying this issue. Remember, the issue referred to has got nothing to do with the Deputy Chief Justice judicial functions. It's a personal matter, but of course it would cast aspersions and create impressions about the person of the Deputy Chief Justice, and it has of course dragged in two innocent third parties, the child and the mother, into this matter. And I think he at least had a moral obligation to take South Africa into his confidence and explain this issue. I don't think the Chief Justice did anything wrong by having a child, and it doesn't even matter that the child, the mother of the child, is the sister of the wife of the former president. I think, as he indicated, this happened long before the former president married the wife in question, whose sister is involved in this matter. So I think it was quite ethical, and I commend the Deputy Chief Justice for taking South Africa into his confidence. I think we are dealing with some measure of toxicity at the Zondo Commission, and we have had a number of things. The Deputy Chief Justice himself has been subjected to personal attacks. He has been accused of things, and I think it's important that when matters of this nature, because these are not even allegations, it's a fact that he had a child when he was in private practice, and that is the case with many other people after all.
And what do you make of exactly that, the kind of toxicity that has been surrounding the Commission of Inquiry and those attacks? I mean, being accused of bias, he must recuse himself. When he makes mention, for example, of bank statements of certain political leaders, and then there's a rebuttal on that to say, well, you're being used in an agenda of some other politicians and so on and so forth. What is the danger of that, particularly to the judiciary?
Look, I think judges, by the nature of their work, go through various difficulties. I think this spectacle that we are seeing around the Zondo Commission is what actually happens quietly in the courts, but because it doesn't necessarily get that kind of attention. And I think judges, their training and their work is of such a nature that, generally judges are very level-headed people. I mean, you would have seen not long ago that there was a judge in the Johannesburg division, Gauteng North, who was insulted by a legal practitioner. There's a judge in the Limpopo division who was called a stupid by a legal practitioner. But the judge composed himself, kept his calm, proceeded with his responsibilities. And I think that it's a pressurized environment, and I don't think people should not think judicial officers are objects who don't have feelings, who don't have emotions. But it is the nature of their work and training which will make them level-headed. I mean, you will see the type of things that happen in the Zondo Commission. You will see the posture of the Deputy Chief Justice. Sometimes you ask yourself, does he sleep at night? And I can tell you that he sleeps. I mean, judges sit there and make very emotional decisions. I mean, you would have seen that case of that lady from Mpumalanga, I think it's Makitla, who was sentenced to, I think, 2 life or 3 life terms.
Yes.
And don't think that the judge didn't have any emotion in that matter. They do have emotions, but the nature of their training is such that they are trained to go through this type of turbulence.
Advocate, we appreciate your time. Thank you very much for joining us tonight. Advocate Mudidima Manya, practicing advocate and former public servant.